Csongor Nagy, who's going to present to you.
Many thanks for the floor. I'm just waiting for the PPTs, which will appear soon. Which will appear soon. So far, Mr. Justice Collins gave you some information on what the law is. I will try to give you some information or some remarks on what the law should be. And I would like to rely or focus on the Allianz judgment of the European Court of Justice, which is not a too which is a fiercely criticized judgment. Of course, I have to add it appears to be still good law, although it was questioned by the Advocate General, it was questioned the scholarship, and its authority is being questioned even today. So first of all, I would like to give you some information on my agenda. Hopefully it works. So the topic I would like to speak about. Unfortunately, it doesn't work. So I wouldn't like to deal exclusively with Allianz. I would like to give you some information on the concept of. Okay, my thanks. So I would like to give you some information on the relevance of the concept of anti-competitive object. But since Mr. Justice Collins has already given you some information on this, I will try to keep this short. I will give you a short overview or summary on the old law on this concept, so anti-competitive by object. Then I would like to make a short outlook to US antitrust law, to per se illegality. And after that, I would like to discuss the judgment in Allianz, and then to evaluate it. So actually, why is the term anti-competitive by object or anti-competitive object so important in competition law? The reason is that this is a very global concept. So you have this in EU law, and you also have this in member state laws, national laws. I checked this. I hope I'm right. It's Article 5 of the Romanian Competition Act, which contains a similar definition and a similar provision. So this is some kind of uniform approach. And we have a very similar approach in the United States of America. Here they don't use the term object, but they use per se illegality. So if something is per se illegal, it's automatically condemned, it's automatically prohibited. You cannot really protect or argue or plead for such an agreement. Also, I have to add that, of course, if something is anti-competitive by object, theoretically you can argue under Article 101(3) that it fulfills the requirements or the conditions of an individual exemption, but practically it's almost impossible to win that battle. So this is a global concept. You have this concept all over the world, this distinction. You have agreements which are automatically prohibited. These are agreements which have an anti-competitive object. These are agreements which are per se illegal. And you have other types of agreements which come under the rule of reason, which are to be assessed on the basis of an effects analysis. This is a very, very important concept because in competition law we have only a few clear-cut rules. So a lot of laymen, non-competition lawyers say that competition law is a swamp. Everything, it depends. The best answer is it depends. Of course, the best answer a lawyer can give to a legal question is always it depends. But this is the more true in case of competition law. Why? Because in most cases, if there's an effects analysis, you have to take the circumstances into account, entry barriers, relevant market, a lot of economic evidence, and so on and so forth. So there are very, very few clear-cut rules in this area, and anti-competitive object is one of them. We also have safe harbors, like the de minimis rule and the block exemption regulations, which are relatively clear-cut, and we have these concepts. So you know what's prohibited, what's automatically prohibited. You should avoid such agreements, but you know that if something is not on this list of agreements, then it will be subjected to an effects analysis. This is a very clear-cut rule. Competition authorities focus on such cases because it's easier to investigate, because you don't have to conduct an effects analysis. You don't need economists, so it's a cheap case. and you can impose very high fines. So these are the best cases for the competition authority. It's easy I mean, if you have the evidence, of course, of the cartel, well, it's easy to prove because you don't have to prove the effects, and you can impose a high fine, so you can make an enormous amount of money using these cases. Now, what is the old doctrine? So this is the law. This is the law in what I learned in the law school. This is the law what I had in mind before Allianz. So this is a relatively old school or ancient approach, but I hope it will be the law in the next decade as well. So what are the rules? Anti-competitive object. This concept is based on boxes. So this is a box approach. You have a box, different categories of agreements, which have an anti-competitive object, which are automatically condemned, but this is not a case-by-case approach. The law doesn't say that you have to take the agreement and the circumstances into account, and you have to decide on a case-by-case basis whether it's anti-competitive by object or not. This is not the core. This is not the gist of this concept. This is a box approach. You have different categories, relatively clear-cut categories like price fixing, market division, limitation of output, and that's all. So no case-by-case approach. How can an agreement, a particular type of an agreement, get on this list? The test is whether it has an anti-competitive nature. Having an anti-competitive nature or being anti-competitive by nature means that it's anti-competitive irrespective of the circumstances. So it doesn't depend on the external circumstances, whether it's anti-competitive or not. It depends on the agreement. It depends on the provisions which are on the paper. You have no general assessment in such cases, so you always remain within the four corners of the agreement. The relevant test is not whether it is generally anti-competitive, I mean whether the agreement restriction is generally anti-competitive. The test is not whether the particular agreement has an anti-competitive nature. The test, which is used in the application of competition law, is whether the particular agreement comes under one of the categories established by the law. This is what I call a box approach. The analysis is textual and not contextual, in the sense that you don't take market into account. Of course, if you read ECJ judgments, you see that they always say that you have to take into account the context, but the context here means that you have to take into account the economic meaning of the agreement, not the effects of the agreement. That context means that you have to take the economic context, the market context into account to understand the agreement. But the judgments, earlier judgments, do not say that you have to conduct an effects analysis, even a truncated one. So context in these judgments doesn't mean effects analysis. It means that if you read the agreement, and you cannot interpret it, you cannot understand it, and you have to take into account the market and the industry and the economic logic of the agreement. That's true, but you don't have to take into account the potential effects of the agreement. So basically, you can remain within the four angles of the contract. Of course, you have to know a little bit about the market to understand what the parties agreed to and what are the provisions. And it's very, very important. Even a legal counsel with a rudimentary understanding of economics should be able to apply these concepts. So the essence of the concept that even foolish lawyers can apply it. And this concept has a lot of advantages. I wouldn't like to enumerate this. So this was the old school. This is in line with US antitrust law. Well, there are minor differences between US law and EU law in this regard, of course, but basically, in principle, there are no huge differences. In US antitrust, we have the concept of per se illegal agreements. These are automatically condemned. This is a box approach as well. So you have these different categories. You apply the categories to particular agreements. If the courts, US courts, do have the power to enlarge the list, to put new types of agreements on this list, and the test is that the agreement must be always or almost always anti-competitive, without the perspective of any redeeming virtue. This is the test in US law. So it must be always or almost always anti-competitive, and the most important evils are covered by this category. They don't have Article 113 in the US, but this is a minor difference from our perspective. So far so good. So we had a concept which is, I think, relatively sound. It is in line with US antitrust. I almost said that it is in line with the oldest antitrust regime of the world, but it's not fully true because, as far as I know, Canada has the oldest antitrust act. But we can say that it's one of the oldest or the second oldest antitrust regime of the world. So this appears to be fine. Now, what was the judgment in Allianz generally, and what are the consequences? So why can it be criticized? It was a very perverted case, very perverse case, and the saying goes that perverse cases entail perverse judgments. Now, this is a perfect example. So what happened in generally? This is a Hungarian case, by the way. Insurance companies concluded contracts with insurance brokers. Insurance brokers are independent advisors. So if you want to conclude an insurance agreement, you go to an insurance broker. The insurance broker is your advisor, not the advisor or the agent of the insurance company. And they will suggest you or recommend to you an insurance product, and if you agree to that, then you conclude a contract. They help you to conclude a contract with the insurance company. So the insurance broker is your guy, not the insurance company's guy. So far, so good. However, who pays the piper? Who pays the insurance broker? In the Hungarian system, it is the insurance company. So you go to the insurance broker, they are expected to recommend to you the best insurance product, or when you conclude a contract with the insurance company pays money to the broker. Of course, this is problematic. They might be biased in a certain sense because, you know, if Allianz pays more for the insurance product as a fee, as a broker's fee than generally, of course, this means that the broker will be inclined to suggest or recommend the product of Allianz because the fee he will get is higher. So you can criticize this arrangement, but this is the normal practice, and it's a global practice, by the way, so it's not only a Hungarian practice. Now, what happened that the insurance companies concluded contracts with brokers, and they fixed target. I mean, they offered fees which depended on the sales targets the broker could achieve. So they said that, look, if your sales, or 40% of your sales are Allianz products, then you get a higher fee. If you sell less than 40%, or you don't meet the targets, you get a lower fee. And in case of repair shops, they used an even more twisted logic. Repair shops are companies which repair your car. So if you suffer an accident, you go to the repair shop, and they repair your car. And once they repaired your car, they go to the insurance company to get the money, because, I mean, in cases the car is covered by insurance. And the insurance company pays them money, including an hourly fee for the reparation services. But at the same time, such repair shops are brokers as well. So you go to the repair shop, they are ready to repair your car, and they are also selling insurance products. And what the insurance companies did in this case, and this was the worst part of the case or of the fact pattern, what the insurance companies did, that they told the repair shop that, look, if you sell my products, you will get a higher hourly fee when you repair cars. So I'm not paying you a higher fee when you sell the products, but if you reach a certain target, so you sell a lot of Allianz products, you will get a normal fee. But when you repair a car and you are asking for the hourly fee for the reparation services, which is a completely separate business, then I will pay you a higher hourly fee. So you sell my products in Avenue 1, and I'm paying you more money in Avenue 2. This was a very twisted logic. So the fee was embedded into the fees of the reparation services. And how did the insurance companies pay that? They paid this because reparation shops were reimbursed or compensated for the cost or the expenses of the reparation services by the insurance companies. So this was a very, very twisted logic. And of course, there was a huge incentive on the side of the reparation shops to push certain products, to push Allianz products or generally products, because in that case, they could earn more money on the reparation services. So there was such a bias on their side. So this was a really, really perverse and strange case. Now, what did the court say? And now comes the legal part of the story. The court tried, and the whole case was the whole case was condemned by the Hungarian Competition Office, and the office said that this is anti-competitive by object, so it should be automatically prohibited. No effects analysis is needed. And the case reached the Hungarian Supreme Court. the Hungarian Supreme Court submitted a preliminary question to the European Court of Justice, and then they received the answer, and the answer was that if you want to declare something anti-competitive by object, you have to take a lot of things into account, including the structure of the market. It's here. More precisely, you have to take into account the alternative distribution channels and market power. It might appear relatively strange, because so far the law was based on a very important distinction. If something is anti-competitive by object, it's automatically prohibited, irrespective of market power, irrespective of market structure, irrespective of market circumstances, irrespective of everything. And if something is not anti-competitive by object, then an effects analysis has to be conducted. So the judgment in Allianz blurred the line between object and effect, and the court said that you have to do some kind of an effects analysis, and if you don't like the agreement, you can condemn it automatically. But you don't have to, and this is the most important problem of the judgment, you don't have to conduct a full-fledged effects analysis. You have a look at the agreement, you take the circumstances into account, and then you automatically condemn it. This is a problematic judgment, because after the judgment, you cannot be sure about what is automatically condemned and what is not, what is anti-competitive by object and what is not. And just a last point, so if something is anti-competitive by object or per se illegal, it should be illegal. This is jurisprudence, the jurisprudence of the court. It should be illegal, it should be prohibited, irrespective of the market share of the parties. So if you conclude a price-fixing agreement, it is prohibited even if you have 2% market share or 3% market share or 50% market share. It's a very important rule on both sides of the Atlantic. Now, what are the repercussions here? It appears to end certainty. And the problem with this approach is that the concept of anti-competitive object is not used to create categories and then to apply these categories, but the concept of anti-competitive object, which is a very, very vague concept, anti-competitive by nature, is applied to flesh and blood matters. And this leads to unexpected results. Sorting occurs after a truncated analysis. There's no effect analysis. The judge or the court or the competition authority on the basis of Allianz has the possibility to pronounce an agreement to be anti-competitive by object after a very short analysis, after a quick look, actually. So they don't have to go into the details of the market. They don't have to find out what are the potential effects. They just have a look at the agreement, a quick look at the market, and then they can say, I don't like the agreement. And this increases the risk of false positives, of course. The general approach before Allianz was that basically all agreements deserve an effects analysis, but there are certain agreements, restrictions, which are automatically condemned. Now, Allianz is putting this upside down. And just a short reference to the new de minimis notice. The old de minimis notice was very good in the sense that it was very predictable. It contained certain market share thresholds. If the parties remain under 10 or 15% market share, they could be sure that they will not go counter to the prohibition of Article 101, and certain types of agreements, restrictions were excluded from the ambit of the safe harbor, but you had an exhaustive list. So you could go through the list and you could check, I'm not meeting this, I'm not meeting the requirements of this, okay, fine, I'm under 10 or 15%, perfect. Now today, we cannot say this, so as a practicing lawyer, you cannot say that, yeah, you meet the requirements of de minimis, because even if your market share is low, you don't know what is anti-competitive by object. There's no exhaustive list of restrictions which are anti-competitive by object. You have an illustrative list, so the sentence which starts with the term, for instance, is not, will not end in an exhaustive list, of course. So there's not too much certainty in the de minimis notice. Of course, you know that there are certain types of agreements which are always prohibited, like price fixing. This is out of question. But if you face an agreement which is not on the list and the market share is still low, you cannot tell the client that, look, you can be 100% sure that this will not qualify as anti-competitive by object. Why? Because you don't have an exhaustive list, you have examples. And perhaps the most important proof of the fact that this is not a perfect judgment, that it appears that the Court of Justice actually did recoil from this creature, from this Frankenstein, in some of the cases, and Mr. Justice Collins mentioned carte bancaire, and I would also like to refer to MasterCard. So these cases suggest that perhaps Allianz was too ambitious. Many thanks for your attention. Thanks.
Thank you, Associate Professor.